Good morning, America. Good afternoon from Europe. Good night to people from Asia and the East. This is Professor Alberto Garcia. Welcome to this webinar organized by the Working Group on Law and Technology that is part of the Global Forum of Law, Justice, and Development. We are very happy today to have this webinar in which we will try to move in a very specific topic related to artificial intelligence in public service and trying to be specific and on the other hand to accomplish what is our mission as a working group, trying to raise awareness within the working group and the global forum in general on the legal and related policy issues at the intersection of law and technology from a perspective of sustainable, equitable, and responsible economic development. On the other hand, we are trying to promote understanding of the development of the impacts of these legal and policy issues within and among members' constituencies, and at the same time to offer, and this is an opportunity, a platform to consider and support practical solutions, including governance and accountability standards, to pressing law and technology questions and challenges. Thank you very much for participating in this webinar on behalf of our co-chairs, Miriam Stankovich, David Satola, and the support of Peter Vince. Welcome to this webinar. We are going to have a registration of this webinar so that you can also follow this webinar later on in our internet site. Thank you for participating, and I give the floor to the moderator of this webinar, Miriam Stankovich, that I appreciate very much for her cooperation, and also the different panelists and partners that have joined us today for you. Thank you.
Thank you, Alberto, for this kind introduction and overview of the work of our working group. Good morning to all of you. It is a pleasure to be with all of you here today. My name is Miriam Stankovich, and I serve as a principal digital policy specialist with the Center for Digital Acceleration at DAI. Now, today, what we are going to discuss is really interesting, and it's current given the latest developments in generative artificial intelligence. Now, what is happening is that governments worldwide, no matter coming from developed or developing countries, are increasingly turning to AI algorithms to automate or support decision-making in public services. Now, algorithms aid in urban planning, they prioritize social care situations, they make choices about our social and welfare entitlements, they detect unemployment fraud, and monitor persons in criminal justice and law enforcement situations. Now, the deployment of these algorithms is frequently perceived as improving efficiency or lowering the costs of public services. However, there is mounting evidence that reveals that these algorithmic systems, when they are deployed, especially in public settings by governments in public service delivery, can also cause harm and breach human rights. And this can be done by reinforcing discrimination and eroding the privacy of digital personal data. And discrimination can happen due to, racial biases, sex, gender biases, etc. So now, since AI algorithms are involved in a plethora, many decision-making processes that affect our lives, the consequences will be dire if we don't have proper safeguards, guardrails for AI, especially when AI is deployed by the government. Now, AI solutions must work for and not against humanity, and as processes become more automated. Now, most countries have yet to invest in initiatives to create public awareness and engage the general public about using algorithms in public service delivery. And this is especially true for countries in development, so developing countries. Now, over the past 2 years, we have seen efforts. So efforts have been made to implement principles through comprehensive algorithmic and AI policy frameworks. We have the Canada's Directive on Government's AI Use, Singapore's Model AI Governance Framework, Japan's social principles of human-centric AI, and the UK guidance on understanding AI ethics and safety. And then we also have the United States coming up with a framework which is based on human rights principles. And we do have the European Union, which is spearheading initiatives. It's at the forefront of AI regulation, and it is the first attempt to implement a complete, robust legal framework governing AI following risk-based methodology. Now, this webinar features star-studded panelists who will talk about their work in algorithmic and AI transparency and accountability. And what's interesting is that we have, panelists coming from Chile, Colombia, and Singapore. And they're going to talk about all these initiatives around the globe, not just in their countries. We do have María Paz Hermosilla. She is currently the director of Lab, a public innovation lab at the Adolfo, Ibáñez University's School of Government, whose mission is to help transform the public sector through data science. She is leading several exciting research projects related to the use of data science to improve public policy, including predictive models in the social sector, the integration of data ethics into the public procurement process, which is very important, and algorithmic transparency. And she was appointed by the Chilean Ministry of Science to the expert advisory committee to create the national strategy for AI and to the National Committee for Public Interest Data. We also have Professor Juan David Gutiérrez, who is an associate professor at the Universidad del Rosario in Colombia, where he teaches and investigates public policy and AI, and he holds a PhD in public policy from the University of Oxford. And last but not least, we do have Professor Mark Findlay, who is a professorial research fellow at the Singapore Management University School of Law. His main research fields, for which he has global reputation, are regulation and governance of artificial intelligence. He was the director of the SMU's Center for AI and Data Governance, working on different AI and data governance initiatives in Southeast Asia. Now, we will start with Maria, with Ms. Hermosilla. Now, Maria, could you please tell us about your role and your interaction with the use of algorithms for public service delivery? Which sectors use algorithms in Chile? What do they use them for? It is our understanding that Chile has demonstrated the power of well-educated, free civil society in enforcing government accountability and transparency, with funding from the Inter-American Development Bank Fair LAC Initiative and the Atlantic Council. Lab conducted extensive research into the Chilean government's use of algorithms, and you drafted and proposed legislation that the government is on track to adopt following initial testing of the regulation with various public bodies. Now, the regulation, that is my understanding, will make Chile the first nation in Latin America to adopt standards on algorithmic transparency. So please tell us about this exciting initiative. The floor is yours. Please take it away.
Thanks, Miriam, and hi, everybody. Thanks for attending this webinar. So as a public innovation lab in a university, we have a double role. One is to study how government is using, algorithms and artificial intelligence, automated decision-making systems to make decisions. And also not just to study how the government is doing them, but to collaborate with the government to make sure they're making a responsible use. So we have several training programs for government officials. We do research, applied research in collaboration with government officials, and we also work together with the government to change regulations to make sure that that there's a governance structure and environment that enables the responsible use of AI. So the project, Miriam, that you were mentioning it's a very big public-private partnership that is funded by the Inter-American Development Bank. And it's called the Ethical Algorithms Project. And in that project, we partnered with several public agencies. And I'm going to refer specifically to the Council for Transparency, which is like the national, it's an independent agency. It's a state agency that does the oversight of the access to information law. So, so this agency, which is it's not a government agency, it's like a state agency, independent, kind of more like the central bank type format of agency, and they actually can interpret the access to information law, the transparency law. And so what we did with them first was, and this is regarding to your question on what algorithms are used for, in 2021, we signed an agreement with them to collaborate on a research study where we surveyed all the agencies that were under the purview of the access to information law, which is 870 different agencies that year in Chile, and a third of them answered. And they responded saying if they were or not using these automated decision-making systems, algorithms. And of those, we identified 92 different systems, and regretfully, 80% of those did not have any public information about them on the website of the public agencies. So the first realization was there's a lot of opacity in the use of algorithms. But we did discover that these algorithms, 78% of them used personal data. About 80% of them were in strategic processes, delivering services and products to the people, education, health, housing, helping detect diseases, helping assign social benefits in jails, to just helping determine benefits for people who are in jail. So these are really important decisions that affect human rights, and there was very little information. And this realization made the Council for Transparency, a few months after we published our joint study, they announced that they wanted to move forward to regulate this sector. The good thing is that they can regulate it without going through Congress, because one of the things we proved in our study was that they had the attributions, the legal attributions to do this, because they have they can put out kind of like a not a law, but it's an interpretation of the law, and it's called an instruction. A general instruction is the technical name. And they actually have put out several of these over the past 3 years. The transparency law in Chile was approved in 2009. So, it's been a while. And so they decided that they were going to put out a general instruction on algorithmic transparency. So what we did last year through the Ethical Algorithms Project and with IDB support was actually do a participatory process to design this regulation. So they wrote a first draft, then we did a workshop with about 25 different public agencies that were going to be regulated. We did 3 workshops. We got all their insights, and then we did a pilot where 4 agencies volunteered. They put out 7 public algorithms that they were using. They actually filled in the information that the regulation is going to request them and oblige them to do. They published it on their websites, and we had a workshop with users of algorithms so they could give feedback to these algorithms. And what we have now is a draft regulation that will be put out for public consultation mid this year. And we expect, if all goes well, for this regulation to be published in October this year, and it will be enforced 1 year later. So by the end of next year, Chile is going to be the government agencies in Chile are going to be mandated to publish information about the algorithms that they use in providing services to citizens. How many of those algorithms are AI? We don't really know. We do have a repository of public sector algorithms. where we host information of algorithms that do have public information. There's 75 systems on it. And we did a revision of how many of those said they were AI, and 52% said they were. But we don't really know if they are or not, because we can't access specific technical information about these algorithms to make sure how many of them are AI. So, but for us, the important thing is that automated decisions are being made, and independent of what the mathematical formula is, it's really important for there to be transparency and accountability for these systems.
Thank you. Thank you so much for this overview, Maria. And you mentioned the difference, and I think a lot of people do not make, ordinary people sometimes do not make difference, do not differentiate between algorithms and AI. So if you could please just touch upon this issue a little bit. So what's the difference between AI and algorithms, so that, we kind of explain to our audience what do we mean by that?
Yeah, no problem. I'll explain it with two examples, real examples. In Chile, we have a system where we assign children to school. And that is not AI. It's a rules-based system based on a law. So the law says, if your brother is in the school, or your sister, if your father is a teacher, if there's certain ifs. So the legislator said, we will assign children to schools in this way, and they put some rules, okay? And then you apply to schools, you put your first option, second option, third option, fourth option, and the algorithm, using these rules that are in the legislation, assigns the spots in the schools. And in the end, once those criteria are ended, it's how do you say, aleatory mechanism. So it's, then
Automatic.
Automatic, aleatorio. How do you say that, Juan David, in English? I'm lost in English. When it's a random. A random factor. So at the very end, the algorithm takes all these rules, and once there's no more rules, it just does a random selection. Okay. So that's a rules-based algorithm. It's actually in the law. That's how they designed the whole student allocation system. We're talking, primary and secondary education. Okay. The artificial intelligence is different. It's based on patterns that are in historical data, and we put a mathematical formula that looks at all this historical data and learns a pattern, and then becomes a mathematical formula that, when it looks at new data, it can give us an output. Okay, so for example, another example in Chile is a system to detect a sickness in the eyes that diabetic people can get, and that can make them blind. Okay, so they took a bunch of pictures of eyes, of retinas, and then these pictures said, this one has a sickness, this one doesn't have a sickness, this one has a sickness, this one doesn't. And it's thousands of pictures of these eyes of people. And then they create a formula, which is actually artificial intelligence. It's actually a neural network. And then when you go to a hospital, you get a picture of your eye. There's an AI algorithm that actually looks at it and says, your eye is healthy, or there is a sign of some of this sickness in your eye. So there are different types of algorithms, both exist, but for normal, citizens who are not in this AI governance discussion, what really matters is that your health is being, evaluated by an algorithm. The spot your child is going to be in school is allocated by an algorithm. This is your life that is being, decided in some way, in important ways, by automation. So it doesn't really matter the mathematical formula. What matters is the impact in people's lives. And that's why it's not that relevant, I think, if the system is or not AI. It's more relevant if it's fair, if the rules are correct, etc., and what's the impact on people's lives.
Thank you so much for this explanation. I think it's worth trying to simplify things so that people who are not involved in AI governance and all these fluffy phrases such as algorithmic governance and accountability and responsibility get a clear picture in their minds what the impact of these mechanisms is, and it's huge. It's huge on our lives. We go to a doctor's office, the doctor uses an algorithm. That's a public service delivery, right? So, and the algorithm decides whether you get tested for certain conditions. That's really important. Thank you so much for this overview. And then we continue with Professor Gutierrez. Juan, same questions for you. So could you please tell us about your role, your interaction with the use of algorithms for public service delivery? What is the situation in Colombia? Which sectors use algorithms? What do they use them for? Are you learning from or modeling, your regulations, if any, in this field on another country? Have any laws been passed on this topic? Does your government mandate specific algorithmic transparency standards? Please take it away.
Well, thank you, Miriam, and good morning, good afternoon, good evening for everyone. Thank you for inviting us today. So, as you mentioned earlier, I research on automated decision-making systems employed by the Colombian state. So I have to say that there are two inspirations for my project. So first, we are actually replicating Maria's work in Chile. She and her GovLab team inspired us to try to do something similar in Colombia. But secondly, we also identified there's a huge gap of information about the use of automated decision-making systems by the Colombian state. So to give you an idea, the previous Colombian government, the previous national administration had included AI and in general emerging technologies as part of their policy agenda, with a focus on creating enabling conditions for the country to use AI, not just the state, but in general the country. And part of this policies included the production or the writing of an ethical framework for the development and use of AI systems, both in the state and the private sector. And in October 2021, this ethical framework was issued. It was sponsored by the national government. And one of the elements of this ethical framework was, let's say, I wouldn't say an obligation, but an invitation to public bodies who use AI systems to register their systems in a dashboard, an online dashboard. So the government opened a web page for AI projects and a specific repository for AI systems used by this Colombian state. But after a year or so, only 6 projects were registered. And nowadays, if you enter the dashboard, the online dashboard, it's not working. So there were only 6 projects. And there's a huge contrast between this and what we had as preliminary evidence of actually a very widespread use of automated decision-making systems. And we had 2 pieces of evidence that allowed us to conclude that there was a huge gap. So the first gap is that there is a national survey answered every year by each public body, and this survey is administered by the national government. And it has around 100 questions. It deals with public management issues, but one of the questions asks each public body to inform whether they use AI or robotic process automation, RPI. And what we saw in the results for 2021 was that over 200 public bodies reported that they used AI or robotic process automation. So we said, well, you only registered 6 projects, but there's over 200 bodies, public bodies saying that they use it. And we know for certain that some of them actually use 2, 3, 4, 5. Some bodies even use more than 10 systems. So there's a huge gap. So that was the first evidence. And second, and this is something that actually María Paz suggested to us when we began our investigation. She told us you should partner with a public body to get more information, or else it's going to be difficult. So we did that. And we conducted an initial survey with the National Planning Unit where we sent to a very short 10-question survey to all the public bodies that had reported that they used AI or robotic process automation to ask them to tell us more about what systems they were using, because we only knew that they said they were using. And we received over 200 registries. That doesn't mean that there's 200 bodies, because as I told you, some bodies use more than one system. And that allowed us to understand that some bodies don't know what AI is or robotic process automation systems are, because some of them reported, let's say, antivirus, firewalls, accounting software, so things that are definitely should not be counted. But many others did effectively register systems that there's no information about, at least at the public basis. I'm actually not speaking about those because we haven't published that survey, and I don't want to provide information that's currently not in public domain. Okay, so we have a clear gap, and we said the Chilean people have done a great work. There's a gap. We should try to do something different, and we did. So currently we have 113 systems that we have mapped. The information is, I mean, the database base it was built with public information, either from the public entity or whether, let's say, there's press reports or some, for example, the OECD or the Inter-American Development Bank sometimes publish reports where they survey what systems are used. So we used any reliable public source to populate our database. So we have 113 systems. And we have developed over 30 variables to characterize each system. We don't have information for each variable. So for example, regarding how much did the system cost, less than 5% of the projects have reported their value. But we have information about most of what are the functions that the systems perform or say they perform, more or less what type of data is used, what bodies are in
It would
charge.
have been my question. Sorry for the interruption.
Yeah.
So data. So do you have any? Do you have variables that relate to data? The data that goes into the
Yeah.
system, especially if it is an AI system, self-learning,
Yeah.
machine learning system.
Sure. So we, I mean, we have basic data about the type of input that it's used. So we don't have detailed information. We have very basic data. But with that basic data, for example, we have concluded something related that it's very important about what systems use personal data. And of course, that's a human rights issue, and it's something that we should be interested to prevent any misuse of personal data. So what we found is that over 74% of the systems that we tracked use personal data. In some cases, it's actually sensible, very sensible. Sorry, not sensible, sensitive, sensitive personal data. Maybe sensible as well, but sensitive. And of course, the question is, well, what type of data? Well, it depends on the system. So I guess I've always spoken about like a general overview of the work, but maybe it's time to give you a bit of a sense of what are these projects or these systems doing. And with this, I'm going to share a couple of slides, if that's okay with you. So just give me a second. Because what we've done is that we have characterized the systems using different classification systems. So one of the systems that we used is the OECD's classification of the functions of government framework, which is actually used by many other countries for many, I mean, they use it for different reasons, but we have found that most of the research on AI use actually use this classification, and we can compare. So for example, the EU's database currently uses that. The Chilean databases also use this form of classification. So we thought, well, we should do that as well. And now I'm going to show you the screen. So apologies in advance because it's in Spanish. But what you're seeing now is that around 31% of the systems are used by public bodies that are part of the economic affairs sector. 23% provide general public services. 19% are used for education purposes. 12% are used for public order and security. 5% for social protection, and then the others are just very small, like culture, environment, health, and defense. We know that our database is biased in the sense that, for example, we imagine that there's many other systems used in the defense sector, but we don't know about them because, of course, we only use public data. Maybe that's also happening in the health sector because in the Chilean case, Miriam can tell us, of course, more about that. They have a lot of systems that are used in the health sector, but apparently in Colombia, the health sector is not revealing their use of AI or automated decision-making systems. And if you make a double click in this pie chart and you visualize the data in a more granular way, you can see how these different broad sectors, this is the second level of the classification of the functions of government systems, you can see more or less how it's actually very broad, the use by different public bodies. Now I'm going to give you some specific examples as Maria Paz did, because I know that I'm explaining this in a very broad sense. But I want to point out something, and it's that we concluded that the classification of functions of government system is very helpful, but it hides some information. Why do I say that it hides information? I'm going back to this one. So you see, for example, that the first type of system that appears to be part of the economic affairs sector. But this hides something. Why? Because I'll give you an example. We've found that several enforcement agencies, such as the antitrust agency, use AI. So Colombia's antitrust agency uses currently 6 different types of artificial intelligence systems. And they are classified as part of the economic affairs sector. But when one sees what type of function is supporting the AI system or the automated decision-making system, it's actually not related to, let's say, how to promote the economy, but actually to enforce the law. So it's more like, it's not, I mean, it could be classified as justice in general. I mean, because it's systems that the antitrust agency uses to screen cartels, to decide whether there's red flags regarding public procurement. So if you use another classification system, not thinking in terms of where is the public body based in the state, but rather to what government function is the system supporting, we have a completely different view. And this is a different pie chart. And you see that the first system that appears there is justice with 18%. Why is it justice? Because as I told you, there's several enforcement agencies that could be located in this economic sector according to the OECD. But if you take the question of, okay, but what type of government activity are they supporting? Then you see another answer. So you see justice, education, environment, and so forth. So I'm going to stop sharing this because I know that I've been using very broad examples, and I would love to give you more detailed answers.
Yeah. Uh-huh.
Yes, Miriam, I guess I've been speaking too much. You should ask me.
No, I was just wondering, and this is a question for all of you. Of course, I'm gonna continue with Mark afterwards, but since both you and Maria gave an overview of the use of algorithmic decision making in the governments of Chile and Colombia, I was wondering, we have algorithmic transparency, but also we have algorithmic accountability, which is a step further, right? So, you disclose all this data as a government agency, okay? So you comply with the law. So the compliance is there. But, I go to the website and I am an ordinary citizen. I do not speak the language of algorithmic transparency and accountability. I take a look at the data, and the data doesn't mean anything to me. So, I was wondering, how do we translate this into something which is more specific for the users, for the ordinary citizens? And also, I was wondering if you have any insights as to whether these public officials that are implementing these algorithmic decision making systems, are they aware of, if it is an AI system, are they aware of the biases that might go into the system? So what data goes into the system? Because if you are deciding on somebody else's, about somebody else's social benefits, welfare entitlements, and we know we have the scandal in Netherlands and in other countries as well, many scandals related to disbursement of welfare entitlements because of skewed data systems, right? So, for example, data that discriminates migrants, or data that discriminates women, or gender or sexual minorities. How do we deal with that? Okay, so it's a loaded question, I know. Any ideas?
Okay. I think that I spoke too much and maybe I can leave someone else, but I do have things to say there.
Okay.
So Maria pass, or if
Maria,
you want something, and
Maria
then I'll
pass.
go ahead.
So the question was, how can we avoid biases in
Yes. So you mentioned that, you're publishing all this data on the website. Okay. So you're publishing data. The data is there about, you have a register of algorithmic decision-making systems, right? So I am an ordinary user. I go to your website, I see this data. Can I make sense of it?
Well, it's so the data that we have on our website just talks about like the purpose of the systems and the
Okay.
general it's the data that's available. So it's not a lot of detailed data. There's not enough data that can allow you to, I would say, evaluate if this system is respecting your rights. Not at all. It's just basically to know that the system exists and kind of what it does and what the public agency said it has accomplished, some kind of results or benefits of the system. And that's about it. So it enables you to just be aware, and then you would definitely have to request information from the public agency under the access to information law that Chile has, which is pretty robust. And you could request information to try to move forward, but it's as actionable as that, which is still better than nothing, but that's where we are currently. And only for the systems we have in a repository. Next year, at the end of the next year, we will have this in all the websites of the public agencies, and there will be much more accountability, but still there's research to be done of the understanding. We've been applying to grants to be able to actually study how much people understand the information that is put out about the algorithms, but that costs money. So until we get the grants, it'll take a while for us to have more insights on that part.
Thank you.
In the case of Colombia, the story is very similar. We don't have enough information about each system to evaluate how it's doing. But I'll start even before. Not all the systems are publicly available. Citizens are not always aware that the state is using certain algorithms. And I'm going to give you at least 3 different examples that are quite worrisome. So currently, the algorithm that classifies people in terms of their income, it's secret, and it's used to determine which family or which person receives government transfers. And it's very well documented how the state has increasingly making more difficult to know how the algorithm operates. And now we have come to the summit of opaqueness, and it's that there's a bill that was just approved in Congress that states that the algorithm that classifies people's income is secret and confidential. So it's a law, which it's not entirely bad news for people who are worried, because the fact that it became a law, it gives us a track to bring it to the Constitutional Court so that the court decides whether
Fight
this
that.
is legal or not.
You have to fight that.
I agree.
Strategic litigation is the next step.
Exactly.
Yes,
Exactly.
yes, I agree.
That will come. That will come for sure. And of course, it's an algorithm that determines whether you get transfers or not. And we know that there's people who have been removed from cash transfer programs without them knowing why, aside from an answer in terms of, well, the algorithm just said so. And that's of course very unfair. I mean, you should have the opportunity of knowing why an algorithm recommended a certain type of decision. And in this case, it's clear that they have to use personal data. I mean, characterizing a person and including them in certain threshold of income, there's personal data there. But unfortunately, Colombian law, data protection law in particular, does not have a rule such as the one found in the GDPR that states that when automated decision-making systems use personal data, there is an obligation for explainability and so forth. That doesn't happen in our data protection law, unfortunately. So there's nothing that really protects citizens from that. And there's another example that illustrates this problem with algorithmic transparency in Colombia. So as many other countries, during the COVID-19 pandemic, the Colombian state used a mobile app. It was Coronap, it was called, where people had to register whether they were sick or not, whether they had symptoms or not, and where they were, and so forth. And there were I mean, some civil society organizations were very wary because they said, well, that for health purposes it makes sense, but we are afraid that you are actually using it for something else, and we are a bit worried because it seems that you are providing this information even to private companies. And that's something that the terms and conditions and the authorization for the treatment of personal data was that's not included. So someone that works at a civil society organization requested the Colombian state formally, using the Access to Public Information Law, to provide the source code of mobile app to understand how the app was working. So first, the Colombian state answered, no, we are not going to provide the source code because that would imply giving you personal data. And then the Colombian civil society organization members answered, no, we are not interested at all in information of people. We just want the code, just the code. So the Colombian state replied again, well, no, we can't provide the code, despite the fact that most of it is open source, because there's cybersecurity concerns, and also because the developer of the mobile app has some intellectual property rights, and we subscribe some NDAs with them, and we cannot offer that information. Goodbye. So the person initiated a constitutional action against the state. And currently, the Constitutional Court, the highest constitutional court in Colombia, is deciding the case, whether the state should have liberated the code or part of the code, or of what information should have prevented. So, like, if you assessed the laws in the books, you would say, oh yeah, Colombia has access to information law. Perfect. We all can know whether the state is using automated decision-making systems and how. In the law in practice, we are not sure whether unless the Constitutional Court forces the national government to provide information about this mobile app, which is not AI, but it was a mobile technology. We don't know if we'll have transparency. And of course, unfortunately in Colombia, we've had previous episodes of illegal state surveillance, and that's why people were worried. I mean, a big human rights problem. So it's not just about how the state uses personal data. It's about the state having had previous episodes of illegal state surveillance.
Thank you. And this is a nice transition into our next speaker. Mark, Singapore has been at the forefront of, AI policy and governance through fostering public-private partnerships, collaborative, agile governance of AI systems. And I know through my work in Southeast Asia, that in Southeast Asia, countries and governments and people have a different understanding of privacy, data privacy, digital privacy, vis-a-vis the Western notions of, privacy. Now, I would like you to tell us a little bit more about your work, and about these initiatives in Singapore that relate to algorithmic transparency and accountability, and just paint a picture of what's going on in Singapore with respect to use of AI. What are the perceptions in government and also for ordinary people about the importance of all of these issues? Because I know Singapore has taken a different approach to Colombia and Chile, for example, in governing artificial intelligence. So please, the floor is yours. Take it away.
Okay, thank you, Maria. I would say, just on the back of some of the questions that you asked earlier on, that the situation in Southeast Asia, certainly, or in the region in which we are, is very different, largely because the majority of regulations are consent-based. They're not legislated in any way. The majority of states that we survey do not have constitutional rights to privacy or constitutional rights to a whole range of things that you necessarily might think would embed a privilege to the data subject, which you would expect in some countries, or certainly expect in Europe. Just before I respond specifically to your invitation, I was thinking about the discussion about how do we make it clearer to individuals about what algorithms are doing and how they can participate in knowing more about the way in which their information is being used. A good example in Singapore is with open banking. Now, it might sound like a private sector issue, but in fact, in Singapore, the Monetary Authority of Singapore, which is the central bank, it is obviously a public sector entity, sets the regulations for the way in which open banking should operate. Now, if I go to a bank in Singapore and I apply for a loan, and the algorithm determines my suitability, the requirement that the MAS puts on the bank is to tell me that my personal data has been used. That's all. If I wanted to find out how the personal data was used or how the decision was made, the authorities have determined that process is not something that should be made available to the data subject. So even if I know, and in most countries in this region people don't know, it's largely useless. The other point I was going to make is this distinction between personal data and other forms of data is again not very clear in Southeast Asia. I don't think it's clear anywhere, to be honest, but it's certainly not clear here. When data goes to the public sector, I am a citizen or a resident, my data goes to the public sector. In many countries in Southeast Asia, that's considered to be the data of the government and not the data of the citizen. And so because of that, that data can be used in a whole variety of different ways. We were talking earlier about what happened in the pandemic. In Singapore, for example, it had one of the earliest and perhaps most developed surveillance apps, which was a development both public and private sector in terms of the development of the technology. And the same assurances were given at the start of that process, that the personal data that would be used would be kept separate and would be aggregated. It didn't take very long to find out, in fact, that that data was open to criminal justice agencies and to the police, and there was a variety of responses, obviously, to that, arguments about the fact that the assurances that the state had given were not to be trusted. But our work actually was stimulated from that pandemic process, largely because if you look at China in particular, the collapsing of public and private data in the process of protecting individuals in terms of their public health safety was enormous. So the Alibaba massive consumer database was collapsed with the public sector database, and that created algorithmic, I would say, oppression, insofar as the red light system in China created the possibility, for example, of individuals to be prohibited from moving from one province to another. And this was based largely on private sector data, which was not open either to the data subject, or when the data subject gave that information to Alibaba, did they ever know eventually that it would go to the private sector. So there are two things perhaps I'd like to introduce in terms of our work. Moving from the point that you make, Mimi, that Singapore has a reasonably well-developed consent-based approach to the protection of private AI systems and the way in which data is used. I would make it clear that that's not applicable to the public sector. In fact, the model framework does not apply to the public sector, it applies to the private sector. But in relation to Singapore, the idea is best practice. Let's make the private sector behave themselves in a way which is consistent with a variety of different standards. All very well if you trust the system to operate that way. But we found as a result of the pandemic that there was a massive amount of public and private data sharing going on across Southeast Asia, which was developing at a very rapid pace and was in fact challenging that whole notion of whether public and private data could be governed in the conventional public law, private law sense. And so we've started a large piece of research which is looking at the governance of smart cities through the surveillance of public and private data. Now, there are two focuses of this project. One is on pervasive surveillance. How are we surveyed, whether it's from using our train ticket to get on the train, or whether it's in our kitchens and bathrooms in a public housing estate being surveilled by infrared surveillance. Or more interestingly, the creation of the super apps which exist now in Malaysia for the delivery of private health services, in Singapore for the delivery of all services. The SingPass, for example, is something that you have to sign up to, and there is no alternative way in which you can gain public services. In Indonesia, for example, Grab has offered their facilities to the state to run all welfare services through a private sector app. Now, you might ask yourself, why would Grab be interested in this? Grab is largely a massive private hire company, which has colonized Asia quite successfully. Why would they be interested in doing this? Will they make money out of it? Pretty much no, but they're interested in the massive amount of public sector data they'll get their hands on. So we've been concerned for two reasons. One is this merging of public and private sector data and the algorithmic use that this stimulates? Because let's not forget, the algorithm isn't the problem. The problem is the data that goes into the algorithm and the way in which the algorithm processes that data, whether it's a mechanical algorithm or whether it's an AI-based algorithm. Excuse me. The second issue we're concerned about is once we know something about this, what are the governance strategies that are in place? Do we have governance strategies? In the old days, we relied on the public sector being accountable through the standards of governance, which would involve, the electoral process, the executive, the judiciary, whatever you like. private sector was accountable to shareholders, and they were accountable then through the market. Now, if you collapse these two together and you don't necessarily show how that collapsing is occurring, nor do you invite the citizen to participate in that process, then the issue becomes much, much murkier and more difficult to understand. So it's not just, do I know there's an algorithm out there using my data, but the question is whose algorithm, whose data, and who's governing it, which has become a real issue. So attached to that, we had a recent workshop with Tilburg University and a number of other partners to examine accountability and transparency in the governance of smart city data. And two things became very clear in that workshop, which involved Indonesia, China, Thailand, Singapore, Korea, India, a variety of other areas in the region. The first thing was that the most developed countries had a more sophisticated issue when they were talking about the relationship between the data subject and accountability. So Korea, for example, were very well developed laws in relation to privacy. So the issues there were issues related to rights and to personal liberties. If you go to Indonesia and to India, and to perhaps a lesser extent, some of the other states we were dealing with, the data subjects know nothing. There's no information available. They don't know where their data is. They don't know who's using it. They wouldn't have a clue. And even if they did, they wouldn't know where to go or what to do about it. And so the information deficit is terrible. And associated with that comes the issue of not just a question about the protection of privacy or the protection of personal rights, particularly through litigation or through state action, but rather the exploitation of data which comes from communities, which comes from areas in which citizens are largely dispossessed from their data in any case. So it's exploitation, it's data integrity, and it's information deficit that became the big issues for us. So when we were looking in that workshop to try and establish a uniform attitude to accountability and to transparency, the thing that became very clear was that while it is an area of significant concern to ask what are the algorithms doing, preceding that, there is a concern to ask who knows what. And associated with that who knows what issue comes your original question, Mimi, about different attitudes to privacy. Let's not forget that in the Southeast Asian region, perhaps 70, maybe 80% of people don't live with any private space, have no private identity which is protected, and associated with that have very fragile rights if they have any. Should they be excluded from the debate simply because they're not in a world where they can activate litigation or where they can understand complicated websites? No, I think what we need to have there is the other end of the argument. What is the state doing and what are the private sector agencies? More importantly, in my view, what's the private sector agencies doing who are becoming the powerhouses here? They're creating the super apps. They're offering the privatization of welfare services. They're creating the chatbots that keep civilians away or residents away from their own data. And the state's quite happy for this because the state doesn't want to have citizen participation in any case. So while I think it's an extremely worthy exercise for us to be asking questions about the algorithm and its use and to put in place wherever possible legislative regulations. If we move back to the Singapore position, which is deep reliance on best practice in the private sector, that depends on the fact that the citizens know that the private sector is using their data and have confidence and trust in that process. In most other parts of Asia, unfortunately, that is not the case. So I'll close on the observation that in our region, there are really two worlds. There is the developed world, which has some government-based rights and attempts to regulate best practice in the private sector, and then there's the rest. And the rest, unfortunately, are really open to quite a wild west of private sector data use, which is largely ungoverned.
Thank you, Mark. This is something that bothers me a lot. Thank you for raising this issue regarding data invisible groups. Okay, so these are groups that are, that are not there. That are invisible to these systems, and I think that both, international actors, international development actors, and also governments and policymakers, when they think of devising regulation, they should think of not excluding these communities. And also, I think we should have a more granular understanding of what privacy and digital and online privacy is in different contexts. And I think that the need for contextualizing all of this is great. So it's big. And I think that that would have been my next question is, you talk about public-private partnerships and, the government collaborating with the private sector companies and, the public and the private merging. And, we cannot make we cannot draw a line where the public ends and the private begins because of the use of these systems, right? So I don't think, and this is a question for all of you. Do you think that, for example, because a lot of governments, especially in international development, and I say this because I work in international development, we get all these requests from international donors and, different governments saying, oh, we would like you to incorporate best practices from the European Union. And I say, hey, it doesn't work that way. Okay, so we can look at what the EU is doing. We can look at what Chile or Singapore are doing, or, Colombia is doing, but we cannot replicate this system. Okay, we need to localize, right? So do you think that, we can take the experience of Singapore or Colombia or Chile and just transpose it in other contexts? And this becomes a conundrum. So it's a challenge, especially in countries that are not as developed in terms of legal and regulatory infrastructure, law enforcement, in digital and data literacy. Hence my question before to Maria Paz and Juan, that it's really difficult because we have to educate the public sector officials that are using these systems, right? So to raise their awareness, digital and data rights, we need to also work with the citizens because some of the citizens or large collectives of citizens are not aware about these issues. Even some of my colleagues who work in digital are not aware of these issues, but they're prominent. We know we talk about algorithms, but there's in algorithms in AI, most of the algorithms are AI already. Okay, so I don't know, Juan, tell us about the story of a Colombian judge using ChatGPT, right, for writing his, to help him write his decision. So these are important issues that we need to address as soon as possible, because I don't think some of the, I wouldn't say it's ignorance, it's just, this technology is developing so fast that a lot of people are not aware that they have AI all over them. It's the Internet of Things sensors. And, I would like to hear your thoughts about this. So how do we approach this challenge? Okay.
Could I jump in quickly and say that
Yes.
if you're dealing with countries, firstly, that do not have a constitutional rights framework, and secondly, do not have a developed regulatory framework for information use. And I'll just caveat that for a second, because I think most regulatory frameworks, even the GDPR, are entirely inadequate because they focus on personal data protection and nothing else. They don't focus on a whole range of other issues that are much more significant, I would suggest, in many ways. and you talk to people in Europe who look at Asia with greedy eyes, thinking, my God, we'd rather be there because we can have open access. But the point that you raise, I think, Mimi, is that even in countries where you have a very limited regulatory frame and a largely ignorant population, you can still have very well developed best practices because the private sector is taking over. So if the private sector is taking over, we might redirect our interests away from an obsession to say, what should the state be doing? How should we make the state do the right thing? Blah, blah, blah. And rather say, okay, if the private sector is getting in there, they have a reputational responsibility to do so in ways that would appear to those outside that country to be acceptable. And I'll give you an example. Microsoft has partnered with the Singapore government to introduce ChatGPT into a whole range of different basic, mundane, clerical services in the Singapore government. And we've had some interesting discussions with both sides, trying to identify the importance of openness in relation to that development, because some of the biggest problems that occur are problems that relate to distrust based on ignorance and misbelief. And both sides have started to see that issue more clearly. And we found with the open banking example, which I gave you a little bit earlier, that even greedy financial institutions are more likely to open up their algorithmic use if they believe that data quality is going to be a byproduct. So if you can teach them that data integrity and data quality can actually be improved through openness, then the sort of neoliberal market thinking comes into play, and you'll find that these private sector agencies come into play. But I'd go back to the point that you made a little bit earlier, Mimi, that if donor agencies come in and want to see a nice model introduced when they give money to vulnerable economies, they shouldn't just look at the state, but they should start looking at the MNCs and say, okay, what are they up to? What's happening with techno-colonialism here, and how can we make sure that the use of these algorithms are acceptable on our standards? You know, the big MNCs unfortunately go a bit like the tobacco companies used to. They go into vulnerable economies and they exploit them with low-level regulation. And that's something that I think that the donors can have a great impact on.
Thank you, Mark. I would like to invite Maria and Juan to comment if you have any comments.
Well, I definitely think that you can't. I mean, there are some things you can import and others you can't, but everything has to go through an adaptation. For us in the ethical algorithms project, which, you know, I explained more about the transparency part of it, but we've been working on piloting things regarding, for example, data protection impact assessments in terms of, you know, better privacy in the use of the data. We've been piloting bias assessments and evaluations of models, and so we've been doing things on different parts of, you know, accountability in the use of algorithms and responsible use and respectful of human rights. So and I would have to say that international regulations and things were useful as a starting point, but they were very high level in general, and so we really had to bring it to our reality. A big thing we've had is most of the tools, for example, are in English, and so then you have to adapt them, or you know, we tried a Canadian tool, we tried American tools. We've been trying different things, and then in the end we end up adapting and to our local reality. So we started for the procurement standards, because we also have a part of this project which is about public procurement of AI. We also started with a World Economic Forum AI procurement in a box toolkit, and we could use part of it, but we really couldn't use like in an exact way. It was very useful, but it wasn't replicable, you know. So in the end, there has to be a processing, and we've ended up having to do everything in Spanish, much more training programs than we thought. We've actually had to strengthen that part of the project and do new trainings, and everything requires, I think, localization, and the barrier in language is really important. For us in Chile, you know, we don't have a lot of English speakers, or at the level of English that they will feel comfortable using English documents. So that's also a big issue. But in terms of the private sector, as Mark was saying, the few experiences we've had in Chile of the private sector in terms of use of data, it's not exemplary at all. And I don't think we could, we need a better data protection law in Chile. Our data protection law is really weak. And so there's like selling of databases and just not a lot of data protection by the private sector. That there's going to, the private sector needs a big upgrade in its practices before, you know, we can kind of trust them to independently do things right. And so we really need to do a lot of work in Chile, both in the public and private sector, in data protection, to at least have basic good practices. And we're currently discussing a reform of the data protection law. Actually, this week it was approved and went into the last final, the final discussion between the House of Representatives and the Senate. It already passed through Senate, passed through House of Representatives, and is now in the final discussion. And hopefully that will come out, and it will mean a lot of work by both the private and public sectors to really establish practices that can make people trust their data use. So
I will stress three things that probably have already been said, but I'm going to try to illustrate them from the Colombian perspective. So I'll start with economist Danny Roderick says public policies not always travel very well. And I would add that technologies not always travel very well. So we have a first challenge, and is developing technologies that are actually useful for our own context, not just importing them. That's one part. So we know that in the global south we are receivers of AI rather than developers, but there's a great question whether the AI developed in the global north is equally useful in the global south. And secondly, what Miriam and others mentioned is a sort of transplanting legal frameworks and processes from other places. In the public management literature and in state capability literature, that's called isomorphic mimicry, trying to just make a mimicry of what others have made, replicating processes and forms, but trying to seem like something, but not actually being able to. And that, I think that may happen with many other legal and policy domains, but in technology and AI, it's clear that if we don't have an institutional and social economics context, well, things that are working abroad may not work here. And a very specific point in Colombia and elsewhere is digital literacy. And you mentioned, Miriam, about Colombian judges using ChatGPT to draft their rulings. And I have to report that it's not just Colombian judges. I have published on reports on Peruvian, Mexican, Bolivian judges who have used ChatGPT during hearings to say, oh, look, ChatGPT says this and that. Or that they copy-paste answers from ChatGPT without clearly reviewing whether whatever the output was trustworthy or not. And it's a matter of judges having a huge backlog of cases, wanting to show that they're doing something about it and saying, oh, well, this is a great match, but ChatGPT will help me to draft things faster and do better my work. But they don't know about the tool is available, it's out there, and it's very easy to use, but they don't know about the limitations of the tool. So I think digital literacy, both at state level, but also just in general for society, is very important. Now, there's a Colombian startup that inserted ChatGPT to WhatsApp, and in Colombia people use WhatsApp very much. I mean, from all ages. It's millions of people using WhatsApp for anything. So this startup just created a bot that you write to the bot as if you were writing to someone else, and the bot will reply the answers generated by ChatGPT. So there's zero barrier to access to this type of large language models. There's access, absolute access, but very few people know how it works, why it works, how it doesn't work, what should be avoided, such as introducing personal or sensitive data. That's something people don't know. So up to now I've said two things, and the third point is that we do need some sort of regulation. I mean, I don't think technology is inevitable. I don't think that we should just simply adapt to whatever is out there. I think that we can regulate certain uses, very specific uses. We can, I mean, so I've heard several times in different forums, oh, we shouldn't regulate the use of technology because then if we regulate today, tomorrow it doesn't work. And well, if that was the case, we wouldn't be regulating how vehicles are used, how we can drive our cars in certain places but not in others, and how fast we can go, and who can drive a car, and so forth. So of course we could have very specific regulations, and I think that we need to learn. Of course, this is an iterative process. It's not a one shot like this is the huge big AI regulation, but no, actually I think we need probably several rounds of tinkering with what works and what doesn't work. And currently there are communities, vulnerable communities, that are being harmed, not just by AI, but in general, but automated decision-making systems. And this, and I don't think it's fair to tell them, oh, well, the market in the long term will solve this. And well, yeah, the benefits are so big that we shouldn't do anything against to regulate the innovation. No, I think there are people and communities that are being affected. We should address why and how we can prevent and mitigate it, and stop discussing about the false dichotomy between innovation and regulation. They both can go hand in hand, and each country has to learn what works in their context and what doesn't work. Just to give you another example about context, Colombia has a general data protection law since the year 2012, and it works very well for private companies. The Colombian agency enforces very actively the law, both when companies or just people misuse data. And it's very, very active. I think it does a great job, but the institutional arrangements for overviewing and controlling how the state uses personal data, that's not working. That's not working because the institutional arrangement is different for public entities in contrast to what happens with the private sector. So although we know for sure that sometimes the states can misuse data, there's not a single decision that sanctions public officials or that mandates public bodies to refrain from misusing data. And that's because our institutional arrangement for that is not working. So, of course, this is very trivial, but institutions matter. And with that,
Can I jump in very quickly and make a point that Juan and Maria have both made, and that is that the introduction of personal data protection, while as a framework it's important, it really isn't the answer for the majority of developing countries, because either public sector data isn't included, or as in Singapore and a number of other states, the exemptions are so wide, particularly exemptions in relation to business benefit, that they become almost irrelevant. And then when you've got that piece of legislation, the state sits back and the private sector sits back and says, well, we've got it here, so just don't complain. And in fact, the regulation is not geared towards the real issue. The real issue is not just personal data, it's data use generally. It's the data use that happens when my data becomes somebody else's data, or when I have layered data, so mine, hers, yours, his, gets put together, and then it ends up going from the health department to the taxation department. So I think what we need to start talking about, and there's not enough discussion of this, is responsible access, to try and create governance frameworks that accept, firstly, the data is going to be accessed, and it's being accessed in a most epidemic way currently. And we have to do something about that, which is at least designed to make access responsible. We're doing research on an area of personal responsibility in data access. And the interesting thing that arises when you look at this sort of discussion is that the majority of people just don't know. And if the first line of, if you like, data awareness is in place, then digital self-determination, for example, is a possibility. But if you don't have that awareness, then we're wasting the time.
I agree with you, Mark, and I agree with you, Juan. So we need regulation, and I agree with Maria. We need to contextualize, and also we need to raise awareness. So we need to work both on supply and demand, right? So both of these issues are very important. And I would like to invite the audience once again, if you have any questions, please ask our wonderful speakers now about their work in algorithmic transparency and accountability. If no questions, I would thank you all. You do have a question, Juan?
I just have a comment about regulation,
Okay.
just a small snippet, and it's that we all know about the EU proposal, and maybe some proposals at the state level in the US. But actually, in Latin America, there are bills in the Congresses of Peru, Colombia, Mexico, and Brazil. I'm maybe missing a fifth one, but there's at least 5 countries that are currently discussing AI bills. I don't know whether they're going to be approved or not, but it is part of the institutional agenda nowadays. So you'll probably hear more from us.
Okay, that's interesting. And I would also like to mention that the United States has come up. It's not a regulation; it's a blueprint for an AI Bill of Rights. And it's interesting because they have the United States government is taking this human rights approach to regulating AI, which is I think if it becomes a robust AI bill, it's going to be a step up from the EU risk-based approach to regulating AI. So it's exciting. We see different countries coming up with different models, I have kind of summarized what we talked about today. So I'm just gonna give a nice overview summary of our discussion. So and I would like this to translate into actionable recommendations for AI transparency and accountability in public service delivery, both for policymakers and for international development donors. I think a human rights based approach or a risk-based approach is essential to building and governing trustworthy AI systems in public service delivery. So that is number one. And then also, I think simplifying things, simplicity, context, and trust are key to achieving algorithmic transparency in public service delivery. So that's number 2. Then also the success of number 3, the success of government accountability and transparency in algorithm usage relies heavily on the ability of non-governmental sectors, both private and citizens, to understand basic digital rights and data usage. Okay, so and access to data, to have access to data meaningful. And then approaches to addressing algorithmic transparency must be tailored to local, cultural, economic, and development contexts. With this, I thank you, Mark, Juan, Maria Paz for this interesting, exciting conversation. We will continue the discussion, and I look forward to staying in touch with all of you. Thank you so much for your attention.